Good evening, everyone. So I hope I am audible and properly visible also to everyone. If not, please comment. Great. So today we are going to have our quiz on Transfer of Property Act 1882. Each one of you will be getting 5 seconds time before answering, right? So uh, the moment the question is shown to you in the on the screen, you will be given a 5 second timer and you will have to answer your just post your answers in the chat box during that 5 second only, right? So I'm going to present my first question. So the first question is, under section 19, vested interest is option A, defeated by death of transferee before he obtains possession, not defeated by death of transferee before he obtains possession, always defeated by death of transferee, none of these. And you have a 5 second time, right, to answer this. So I have not received any answer yet. If anyone is interested in answering the first question, please answer. Please comment in the chat box. Under section 19, vested interest is defeated by death of transferee before he obtains possession, not defeated by death of transferee before he obtains possession, always defeated by death of transferee, none of these. Please tell your answers, students. I'm waiting. What do you think is the answer to number one? Okay, so I have got first answer and it is right. Right. The option is option, which option, Cheyenne? Will the option be defeated A, B, or C, or D? Please write the option also. So the correct answer is option B, not defeated by death of transferee, right? So the answer is correct, Cheyenne. Also, you mentioned one, B, and then you mention your answer, defeated or not defeated. Okay, so just write the question also, like for one, write one B, for two, write two A, like that. Okay. My second question is this. A transfers rupees 500 to B on condition that he shall execute a certain lease within 3 months after A's death, and if he should neglect to do so, to C, B dies in A's lifetime. So, what will be the correct answer? The deposition in favor of C will take effect. The disposition shall not take effect in favor of C. The disposition requires further agreement. None of these. So, if you can see my question number two, if you are writing the answer, also mention the question number, please, like 2A, 2B, because I think since we are in live session, my question might reach out to you, like, after 5 seconds or 3 seconds, and then you have answered question number one, but it will, like, I'm still in, I have gone to question number two. So always mention the question number also. Ankita is, it's not visible to Ankita. Ankita, I'm in question number two. Can you see question number two? A transfers rupees 500 to B on condition. That he shall execute a certain lease within 3 months after A's death. Is question number 2 visible to everyone? And if we should neglect to do so, to C. B dies in A's lifetime. So these are my options. Is it visible to everyone, students, or not? If not, please tell me. Question number 2, not visible. Okay. Okay, I'll just check it. Is now question number 2 visible? Is now question number 2 visible to everyone? I think it will be visible to you now. Yes. So if question number 2 is visible, please answer. And always write like 2A, 2B. Always write your answer in this way, okay? So what will be the answer to question number 2? Any guesses or any short answers? Come on, students, answer it. So it's more than 5 seconds. I'll have to take up this question and answer. The correct answer is option A, right? It is disposition in favor of C will take effect, right? Disposition in favor of C will take effect. So the correct answer to this is option A. Disposition in favor of C will take effect. Okay. So I'm going to question number 3. Please check this question also. Question number 3 says the foundation of doctrine of election under TP Act 1882 is that a person taking the benefit of an instrument must bear the burden, must not bear the burden. Option C is burden is not the subject matter, and option D is none of these. Please answer. Shai and Ankita, are you all there to answer? I can't see any answers. What is the answer to question number 3? Is it clearly visible? My screen is clearly visible to everyone. Yes, students, is my screen clearly visible to everyone? Who can tell me the answer to question number 3? Yes, so any guesses to question number 3? Any guesses to question number 3? The answer to 3 is A. So the one who is taking the benefit of an instrument should also bear the burden. So for question number 3, the answer is A, option A. I don't know why you people are not answering. Please answer whatever you feel like, whatever you have studied, whatever logic you can put to this, to the questions, but please answer. See question number 4. The mortgager's right to redeem the mortgage property accrues at option A, any time after the mortgage, option B, any time after the mortgage money becomes due, option C, any time when the mortgager wants, and option D, at any time mortgagee demands the money. Please write your answers in the chat box to question number 4. Anyone who can tell me the answer to question number 4? What will be the answer to question number 4? The mortgage's right to redeem the mortgage property accrues at what time? See the 4 options and let me know the answer. Okay, so Priya has written option C for 4, right? Okay, any other answers to this? When does the mortgage's right to redeem the mortgage property accrue? It is at any time when the mortgager wants. So the mortgager right to, you know, this is what Priya has written, that is at any time when the mortgager wants. But why, what will be the correct answer? See all the options: at any time after the mortgage, at any time after the mortgage money becomes due, at any time when the mortgager wants, at any time the mortgagee demands the money. What do you think will be the correct answer? The correct answer is option B. Okay. So for the correct answer is option B. At any time after the mortgage money becomes due, the mortgager has a right to redeem, and his right to redeem accrues at that time after the mortgage money becomes due. So the correct option is option B. Now come to question number 5. Tell me, if you have read about this case, Jayalal Poddar versus Bibi Hajra, what doctrine is this case related to? Jayalal Poddar versus Bibi Hajra is related to what doctrine? Doctrine of election, doctrine of part performance, transfer by unauthorized person, or option D, ostensible owner. Please tell me the answer to question number 5. See all these questions which are being you know see given here in this slide, which you can see has come in the previous years also. If you see the previous year or the past year question papers, you will find these questions in the preliminary examination. So which doctrine is this case of Jayadayal Poddar versus Bibi Hajra related to? Please tell me the correct option for 5. Anyone who can tell me the correct option. Please write your answers fatafat, like quickly, as quick as you can do in 5 seconds. No answer is coming. This is a very famous case in TP Act, Jayadayal Poddar versus Bibi Hajra. Yes. If you have gone through this case, you can easily tell me what is this case related to? Which case is this case related to? Which doctrine? Which what was the dispute here? The answer to question number 5 is option D, ostensible owner. If you see the case summary or the case judgment, it's related with Benami transaction and ostensible owner. It's such a famous case in TP Act. Jayadayal Poddar versus Bibi Hajra. I don't know why you people are not able to give this answer. Okay, let's move on to the next question. Right, I'll show you question number 6. Now tell me, which of the following can be considered implied surrender of the lease? Which of the following can be considered as an implied surrender of the lease? Option A, acceptance of a new lease taking effect during the continuance of existing lease. Option B, abandonment of possession by the lessee. Option C, lessee yields up his interest under the lease to the lessor by mutual agreement between them. And option D, none of these. Please read the question and tell me the answer to question number 6. What is the correct answer to question number 6? Which of the following can be considered implied surrender of lease? Any answer from your side? The correct answer to question number 6 is A, option A. It is acceptance of a new lease taking effect during the continuance of existing lease. Students, please see the answers. I'm just posting that I'm also posting in the comment box for you all. 6A is the correct answer. I'll move on to the next question, question number 7. Just see question number 7. Okay, students, can you see question number 7? I'm not going to move forward if I'm not receiving the answer in the chat box for question number 7. Yes. What will be the answer to question number 7? What do you think? Please see question number 7. The right of a third person for maintenance cannot be enforced under section 39 against transferee who is option A gratuitous, option B consideration without notice of right, option C gratuitous transferee without notice, and option D for consideration but with notice of the right. So what do you think is the correct answer here? See, these questions have come in the previous year prelim paper also of MP Judiciary. So if you are unable to answer them, then you know it is problematic and you will have to brush up TP Act again. So please tell me the answer to question number 7. The correct answer here is option B for consideration without notice of right. So for 7, the correct answer is option B. Yes, right. So for this, I can see one answer which is B, and that is the correct answer, right? So it's 7B. Now I'm moving to the next question, question number 8. A lease of immovable property is not compulsorily registrable. Options are lease from year to year, lease for a term of 1 year, lease which is receiving a yearly rent, none of these. So among these, which one is not compulsorily registrable? Please write your answer in the chat box for 8. Okay. So 8D correct, none of these. The answer is correct. 8D, none of these. Question number 9. The condition restraining absolute alienation is not void when it is, see the options, for the benefit of the lessor, for the benefit of the legal heir of the lessee, for the benefit of the lessee, none of these. What will be the correct answer to question number 9? The condition restraining absolute alienation is not void when it is for the benefit of lessor, for the benefit of legal heir of lessee, for benefit of lessee, and none of these. So I'm receiving an answer D, which is for question number 9, it will be A for benefit of lesser. Okay, for question number 9, the correct answer is A for the benefit of lesser. Question number 10. According to provisions of TPA, easement can be transferred, cannot be transferred, cannot be transferred apart from dominant heritage, and can be transferred apart from dominant heritage. What do you think is the correct answer here? According to the provisions of TPA, easement can be transferred or cannot be transferred or can be transferred apart from dominant heritage or cannot be transferred apart from dominant heritage. Yes. What do you think is the correct answer? Okay. So the correct answer here is option C. It cannot be transferred apart from dominant heritage. For question number 10, the correct answer is C. I'll just write it in the chat box also. Now, why? If you see section 6, clause C of TP Act, okay? Section 6, clause C of TP Act, if you see, it says that Easement cannot be transferred apart from dominant heritage, right? So for 10, the correct answer is 10C. It cannot be transferred. Come to question number 11. When two people mutually transfer the ownership of one thing for ownership of another, neither thing or both things being money only, the transaction is called. Now, this is a very easy question. I am sure you people can answer this. Yes, yes, Vikas, right. The correct answer is exchange, option D. And which section of TP Act talks about exchange? In which section do we see exchange under TP Act? In which section do we see exchange? Can you mention the section also for exchange, students? Yes, very good. Section 118, correct. Section 118 talks about TP Act. Thank you, Vikas. Now I will move on to question number 12. See the question. A sells his house to B on a condition that B cannot transfer his house to anyone except C. The sale is valid, but condition is void. The sale is void. The sale is unlawful, or the sale is voidable. So, if there is a condition under which the house is being sold, what will be the correct answer? B. Vikas says it is void. Okay. And and don't you think if I'm selling my house to you with a condition, then that sale is valid, right? A. Very good, Vikas. Priyanka has mentioned A. Correct. So the correct answer is A. That means the sale is valid, but condition is void. Sale is valid, but the condition is void. Can you tell me, which section talks about this? In which section do we find that the sale is valid, but the condition is void? So if you see section 10, right? Section 10 talks about condition restraining alienation, right? So if I'm transferring a property with a condition or with a limitation absolutely restraining the transferee uh, or any person to part with it or to dispose of his interest, then the condition is void. But there is an exception also in this, and that is in case of lease. If the condition is for benefit of lessor or those claiming under him. So the exception to section 10 is lease. Otherwise, the thing is valid, the transfer is valid, but the condition is void in such cases. Come to 13. Subrogation is mentioned in which section? Very easy. Where do you find subrogation? Where do you find subrogation in which section? Vikas, Priyanka, anyone who can tell me? D. Very good, Vikas. Yes, subrogation is mentioned in section 92 of TP Act. Correct. Okay, come to 14. In which transaction no interest in property is created? In which of these transactions no interest in property is created? Will the answer be lease, or it will be license, or mortgage? What do you think? Or tenancy? In which transaction no interest in the property is created? Tell me the answer to question number 14. B. Very good. Tenancy. Right. Sorry, license. Right. So the answer to this is option B. That is license. Okay. For 14. Come to 15. An instrument is what? Under TP Act, an instrument is what? Is it a testamentary instrument, a non-testamentary instrument, an official document, or all of them? What will be the answer? Okay. So if you see section 3 of TP Act, right? If you see section 3 of TP Act, I would have shown you for that again. I'll to change the screen. Instrument means a non-testamentary instrument. Under section 3 of TP Act, you will find that instrument is a non-testamentary instrument. So the correct answer to section 15 is non-testamentary instrument. Is it clear to everyone? For question number 15, non-testamentary instrument. Okay. Now we will move on to 16th question. Who may sue for redemption? Who can sue for redemption? Mortgager, mortgagee, both of them or none of them? Easy question. ये तो कोई भी आंसर कर सकता है. अगर आपने पढ़ा है तो you can answer this question very easily. Acha, with your answers, you know, with you write the question number also, like 16A, 16B, whatever question you are answering. A, very good. The correct answer, right, Priyanka? It is A, mortgager. So mortgager may sue for redemption. Yes, mortgager may sue for redemption. Come to question number 17. Now, this is a little, you know, little we can say one level up question. Section 41 of TP Act provides which of the following remedies to a bona fide purchaser for value without notice? An equitable remedy, equal remedy, fair remedy, or all of this? For question number 17. Yes, Priyanka. For 16A, right. What about 17? What about 17? 17A. So, yes, if I tell you the answer, it is 17A, correct. So, if you see section 41, it is transfer, which deals with transfer by ostensible owner, right? And it provides for an equitable remedy to a bona fide purchaser for value without notice. So, the answer to section 17 is equitable remedy only. Come to section 18. Provisions relating to part performance have been enshrined under which section? Very easy question. Which section of TP Act tells about part performance? Right. The correct answer to 17 is A, right, Priyanka? Yes. For question number 18, it is the answer is B. Right. For 18, it is B. Writing it to remove confusion. For 17, it is A. And for 18, it is B. Right. For 18, it is section 53A talks about Part performance. Doctrine of part performance is said in section 53A. Okay, question number 19. Which of the following can be considered as a transferable property? Which of the following can be considered as a transferable property? Actionable claim, pension, right of way, or change in legacy? Tell me. Which is a transferable property under section 19? Vikas says A, Priyanka says A. Right. The correct answer is A only. It is actionable claim. Very good, both of you. The correct answer to question number 19 is actionable claim. So, actionable claim can be transferred. Okay. If you are transferring an actionable claim, whether with consideration or whether without consideration, that is going to be affected only by the execution of instrument, which should be in writing. It should be signed by the transferor also or his duly authorized agent, right? So the correct answer to question number 19 is actionable claim. Good. Come to 20. This is also easy. Marshalling कहाँ देखा है आपने बताओ? Marshalling by subsequent purchaser is dealt with under which section of TP Act? Marshalling by subsequent purchaser is dealt under which section of TP Act? Come to question number 20 and answer it quickly. 20D is what Priyanka says. Correct. It is section 56, right? So section 56 talks about marshalling by subsequent purchaser. Now many students also get confused between marshalling. Okay, they don't know whether to answer. If it is all in 50, the question, the options are all in 50s, then it is 56. But sometimes the option might be also section 81, right? But that is not for subsequent purchaser, that is for marshalling securities in mortgage. So be very careful when you are marking the option if section 56 and section 81 both are given in your option, because both deal with marshalling. But 56 is dealing with marshalling by subsequent purchaser in sale chapter, and 81 is dealing with marshalling securities under the chapter of mortgage, right? Okay, come to this question 21. A gives a lakh of rupees to B, reserving to himself with B's assent the right to take back at pleasure rupees 10,000 out of that lakh. Which of the following is correct in regard? The gift holds good as to rupees 90,000 but is void as to rupees 10,000, which continues to belong to A. The gift holds good for the entire amount of 1 lakh. The gift holds goods as to rupees 10,000 but is void as to 90,000, which continues to belong to A. Now these two options are same. No, the options are not same. Here it is 90,000 and here it is 10,000. Okay, and the gift is invalid for the entire amount. So tell me the correct answer to this also. 21. What is the correct answer to question number 21? Vikas says C. Okay. What about others? So A has said that I'm giving you a lakh of rupees, and that too, he's gifting it. He's gifting that amount to B. And with B's assent, he also has a right to take back at pleasure rupees 10,000 out of the lakh. So, will the gift hold good for the whole amount, or will the gift hold good only for 90,000? What do you think? The correct answer is A. Why, students? The gift is only holding good as to rupees 90,000. It is void for the 10,000 rupees, which A says I will be taking back any time, right? Which A says I'll be taking any time. Why? Because if you see this, Section 126, right? When gift may be suspended or revoked. When gift may be suspended or revoked. So if you see section 126 of TP Act, right, for 21 the correct answer is A. Why? Because आपके पास अगर बेयर एक्ट है, या if you can mark it down, if you see section 126, right, and the illustration which is given in section 126. नाउ सेक्शन 126 में आप अगर इलस्ट्रेशन देखो, आई डोंट नो इफ आई कैन शो यू द इलस्ट्रेशन, वेट आई विल शो यू, right? So I'll just quickly go to 126. Can you see the illustration here, students? It's the same illustration which I have given you in question number 21. Right? A gives a lakh of rupees to B, reserving to himself with B thus in the right to take back at pleasure rupees 10,000 out of the lakh. The gift holds good as to rupees 90,000 but is void as to rupees 10,000, which continues to belong to A. Right? Okay. So coming back to the questions now. Question number 22. Which of the following best defines onerous gift? So where is onerous gift mentioned? First, you all tell me. Where is onerous gift mentioned, and what will be the correct answer to this option? To this question, you have four options: gift of property in bulk by a single transfer, gift of several things by a single transfer, of which one is burdened by an obligation, gift of a burdened property, oppressive or burdensome gift. So, which is the proper definition of onerous gift, and which section defines onerous gift? Tell me the section and tell me the correct answer. Two students, come on, 22. The correct answer to 22 is, आप बताओ कि अच्छा, where do you find this onerous gift का section? Where do you find this onerous gift का section? It's under which section, students? Anyone who can tell me the section of onerous gift? It's section 127, right? Section 127 talks about onerous gift. And if you see the definition, it says, where a gift is in the form of a single transfer to the same person of several things, of which one is and others are not burdened by an obligation, the donee can take nothing by the gift unless he accepts it fully. And whereas the gift is in form of two or more separate and independent transfer to same person of several things, the donee is at liberty to accept one of them and refuse the other, although the former may be beneficial and the latter are onerous. Right? So, if you see the correct answer to question number 22, it is what? According to section 127, if the gift is in form of a single transfer to same person of several things, so I'm giving you several things of which one is and others are not burdened by an obligation, the donee can take nothing by the gift unless he's accepting it fully. And where he is in the form of like two separate gifts, right, to the same person, and he is again at liberty to accept one of them and refuse the other. So, what is happening here? Although the former may be beneficial and the latter may be onerous. So, the correct answer is C, gift of a burdened property. Either you are gifting him, like, several things. Now, see, B can also be correct, of which one is burdened by an obligation, but it can also be something, which is in two separate forms, not only single transfer, it is also separate transfer also. So keep in mind that it is gift of burden property. Whenever I'm talking about onerous gift, I'm talking about burden property. So the correct answer will be C and not A or B. Okay. Come to the next section, which is our 23. Which is which section is talking about feeding the grant by stopple? See the sections and tell me. 42, 43, 44, 45. Which section talks about feeding the grant by stopple? Yes. So feeding the grant by stopple is mentioned in section 43. Very good, Priyanka. Come to next question. Which of the following rule has been provided in the famous Pinel case? Part performance, minor's contract, fraud, or undue influence? What do you think is the correct answer to question number 24? Please tell me the correct answer to question number 24. So for 24, the answers coming are A, D. Right. So Priyanka says A and Durva says D. Now, Pinel case is related with the doctrine of part performance. Okay. So if you see the case, Pinel case, that is related with part performance. So the correct answer is option A. Because penal case, if you read, it's also known as Penny versus Cole, and it also important in contract law and on doctrine of part performance. Okay. Come to 25. If the transferee takes possession of immovable property in part performance of contract, and he is ready and willing to perform his part of contract, then what will be the correct option here? A, B, C, and D are given. Tell me the correct option for 25. If the transferee takes possession of immovable property in part performance of contract and is ready and willing to perform his part of contract, then what is the correct option here? A, B, C, or D? Yes, students, please mention your answer. He can obtain the relief of specific performance, notwithstanding the law of limitation. He can get a decree declaring the title. He can protect his position. None of these. Priyanka says A. What about others? So, if the transferee has already taken the possession of immovable property and he's also ready and willing to do his, to perform his part of the contract, then What does section 53A says? See section 53A and then answer. Take a moment and read the section. So the correct option here is he can protect his position, right? So of course he can obtain relief of specific performance, but when you know, he can also protect his position. He can protect his position. That is the biggest part. No one can take his position if he's willing to perform his part of contract and he's already taken the position. The correct answer here is 25 is C. Come to 26 now. A transfers rupees 500 to B to be paid to him on his attaining his majority or marrying with a proviso that if B dies a minor or marries without C's consent, the rupees 500 shall go to D. B marries when he is only 17 years of age without C's consent. So here the transfer will take effect, will not take effect, or the transfer to D may take effect depending on circumstances, or none of the above. What do you think? So either he can take the property on majority or marrying, and there is a proviso that if B is dying as a minor, or if B is marrying without C's consent, then rupees 500 shall go to D. Now B marries at minority only, right? Only when he's 17 years of age, and that too without the consent of C. So what will happen to the property? Will it go to D or will it not go to D? Please write your answer and also mention the question number with your answer. Yes, what will be the answer here? The correct answer to question number 26 is, students, tell me. The correct answer here is B. The transfer to D will take effect. See section 29 and the illustration. Wait, I'll see if I can show you the section. So if I show you section 29 and the illustration to it, can you all see this? Same illustration, right? So it's section 29 and the transfer to D will take effect according to section 29, that is fulfillment of condition subsequent. I hope this question is answered to everyone. Yes. So the correct option to question number 26 is B. The transfer will take effect, right? Come to 27. Under TP Act, when can an unborn person acquire vested interest on transfer for his benefit? Upon his birth, upon completing his majority age, upon his marriage, none of the above. Which is the correct option? Tell me. So, when will an unborn person acquire his vested interest? Please write the answer 27 and then you mention your answer. So, mention the question number also. What is the answer to 27? Durva says A. So I have received the first answer. The correct answer is A. So भले ही उसको पोजीशन बाद में मिले बट आप वेस्टेड इंटरेस्ट तो तभी हो जाता है ऑन हिज बर्थ, राइट? सो द करेक्ट आंसर इज अपॉन हिज बर्थ. इफ यू सी सेक्शन 20 ऑफ टीपी एक्ट, you will find that he acquires the vested interest upon his birth. So correct, Durva, the correct answer is 27A. Moving forward, under TP Act, remedy of foreclosure is available under which of the following mortgages? Now, with each mortgage, there is a remedy. So, foreclosure will be available under which of these following mortgages? Mortgage by conditional sale, English mortgage, usufructory mortgage, or simple mortgage? Please mention the question number and then mention your answer. In which of the mortgages you have this remedy of foreclosure? Twenty-eight C. Priyanka says C. Right. So, see, foreclosure is a remedy which is only available in mortgage by conditional sale. It's only available in mortgage by conditional sale. And sometimes, according to the terms of the contract, if anomalous mortgage also allows it, then in anomalous mortgage also you get it. Like according to the terms of the contract, of course, it depends upon the terms of the contract, but generally you get this foreclosure remedy in mortgage by conditional sale. So remember this. In usufructory mortgage you will not get, because usufructory mein to aap already you are taking the benefits also, and you are clearing your mortgage debt according to it. So the correct answer, नो, फोरक्लोजर स्टूडेंट्स, देखो आप देखो ये जो क्वेश्चन इज रिलेटिंग टू फोरक्लोजर, and the remedy of foreclosure is only available in mortgage by conditional sale, only available in mortgage by conditional sale, and sometimes according to the terms of the contract you also get it in anomalous mortgage, but the correct answer is A here. So mortgage by conditional sale, right? Mortgage by conditional sale is defined in section 58 clause C, where the remedy is foreclosure. Coming to next question. What does section 36 deal with? TP Act 36 is dealing with what? Tell me the answer to question number 29. TP Act. Yes. So Durva has already mentioned. I guess no, she's not. Okay, come to question number 29 now, students. The correct answer to 28 was A. Yes, coming to 29, if you all see question number 29, the correct answer here is 36 deals with doctrine of what, students? Apportionment. So the correct answer is D. Doctrine of apportionment. I can show you the right. Yes, Durva. The correct answer is 29D. Yes, Priyanka, correct. Moving on to next question, 30. अब देखो यहाँ पे दो स्टेटमेंट्स है, आप लोग इसको बहुत ध्यान से पढ़ना. Statement A says every transfer of immovable property made with intent to defeat or delay creditors of transferor is void. And statement B says every transfer of immovable property made without consideration with intent to defraud a subsequent transferee is void. So कौन सा स्टेटमेंट करेक्ट है? ए, बी या दोनों करेक्ट है या दोनों ही इनकरेक्ट है? आप बताओ. Are both statements correct or are both statements incorrect, or one is correct? Whichever is correct, आप बता दो. Read both the statements to question number 30 and tell me the answer. थर्टी का आंसर आप बता रहे हो करेक्ट है. अगर आप आपने ध्यान से यहाँ पढ़ा क्वेश्चन नंबर 30, मैंने दोनों जगह यहाँ पे देखो क्या लिखा है, void and void. बट इफ यू रीड सेक्शन 53 फ्रॉडलेंट ट्रांसफर का डेफिनेशन, तो वहाँ void है या voidable है? व्हाट इज द फ्रॉडलेंट ट्रांसफर जो होता है वो void होता है या voidable होता है अकॉर्डिंग टू सेक्शन 53? आई फील एंड आई नो द आंसर इज इनकरेक्ट. व्हाई? बिकॉज यहाँ पे जो void है ना, वो void नहीं होना चाहिए, voidable होना चाहिए. 53 अगर आप पढ़ोगे ना, so it is voidable at the option of the creditor, voidable at the option of the transferee, right? Yes, so the statements are incorrect because वहां पे statements में हमने क्या देखा, क्या लिखा है? statements में लिखा है void, void लिखा है, लेकिन correct answer क्या है? voidable, right? तो ये कुछ माइन्यूट चीजें आपको ध्यान देना है so that your answer is not wrong. Come to 31. Where an interest is created in favor of a person to take effect only on happening of a specified uncertain event, it is vested, contingent, absolute or conditional. आप बताओ. What will be the answer to question number 31? Please tell me the answer to question number 31. Yes, the correct answer is option B, and that is contingent interest. Very good, Priyanka. Right. So, if it is created in favor of a person, which is going to take effect only on happening of a specified uncertain event, it is contingent interest. Very good. Moving on to next question. A lets to be a farm on the condition that B shall walk 100 miles in an hour. The lease here is what? Student, tell me. Voidable, void, valid, enforceable. आप बताओ. 100 miles in an hour चलना है, right? So lease is void, voidable, valid. आप बताओ. So the answer is coming is void. Very good. Yes, the answer is void. And which section, students? Which section is this related with? सेक्शन बता सकता है कोई? 32 किस सेक्शन से रिलेटेड है? कहाँ पे ये इलस्ट्रेशन हमें मिलेगा इन टीपी एक्ट? Where do you get this provision in TP Act, students? I'll drink water. आप मेरे को बताओ तब तक कि ये कौन से सेक्शन में है. Yes. No answers to the section. Priyanka, Durva, tell me. ये सेम इलस्ट्रेशन हमें किस सेक्शन में मिलने वाला है? अगर आप सेक्शन 25 कंडीशनल ट्रांसफर का इलस्ट्रेशन ए देखो, सेक्शन 25 which deals with conditional transfer, उसका आप इलस्ट्रेशन ए देखो तो सेम आपको मिलेगा, सेम इलस्ट्रेशन एंड द लीज इज वॉइड. ओके, कमिंग टू नेक्स्ट क्वेश्चन 33. अच्छा बताओ, विच सेक्शन इलस्ट्रेट्स बेनामी ट्रांजैक्शन? बेनामी ट्रांजैक्शन किस सेक्शन में है? मेंशन द ऑप्शन स्टूडेंट्स. Where do you find Benami transaction? #41. Very good, Priyanka. Right. So the correct option here is B. है ना, ostensible owner वाला जो section है हमारा, transfer by ostensible owner, that is only dealing with Benami transactions also. Good. Okay. Which section of TP Act provides for joint transfer? Joint transfers किस section में है? 33 का आंसर as I told, it's B, right? 33 का आंसर is B. Option B, section 41, है ना? Tell me the answer to section 34 now. Which section of TPX provides for joint transfer? #34, you people are saying A. A, that is 44 and 45. And what about 45 and 46, students? What about 45 and 46? So will it be 44 and 45 or will it be 45 and 46? Come on, tell me the answer to question number 34. 45 is to sure, but will it be 44 or will it be with 46? See, 44 deals with what? 44 deals with what, student? Yes, Priyanka, right. It's confusing, right? So देखो हम बताते हैं 44 जो अगर आप देखोगे ना 44 डील्स विथ को ओनर है ना ट्रांसफर बाय को ओनर अगर हम देखें तो वो ट्रांसफर बाय को ओनर है एंड प्रॉपर्टीज जॉइंटली ओन्ड जहां पर आप देखोगे अगर पढ़ोगे प्रॉपरली तो उसमें लिखता 44 में लिखा है द प्रॉपर्टीज जॉइंटली ओन्ड बाय टू और मोर पर्सन एंड इट इज अ को ओन्ड प्रॉपर्टी जहां पे कोऑनर के इक्वल या इनइक्वल शेयर्स हो सकते हैं राइट नाउ वन थिंग विच आई वांट टू टेल यू ऑल इज दैट 45 तो बिल्कुल श्योर है कि 45 तो होना ही है तो हमारा ऑप्शन सी एंड ऑप्शन बी तो ऐसे ही एलिमिनेट हो जाता है या तो वो सेक्शन या तो वो ऑप्शन ए है या तो वो ऑप्शन बी है राइट 44 एंड 45 है या 45 एंड 46 है बिकॉज 45 हमारा श्योर श्योर जॉइंट ओनर के साथ डील कर रहा है बट वन थिंग जॉइंट ट्रांसफरर्स जो होते हैं ना दे नीड नॉट नेसेसरीली बी को ओनर जो जॉइंट ट्रांसफरर होते हैं बिकॉज वी आर टॉकिंग अबाउट जॉइंट ट्रांसफर राइट सो जॉइंट ट्रांसफरर्स जो होते हैं वो को ओनर्स नहीं भी हो सकते so they may be persons having different kind of interest by way of different title in respect of property so the correct answer here is 45 and 46 because joint owners जो होते हैं वो जरूरी नहीं है that you know co-owners भी हो right so that is why the correct answer here is option B 45 and 46 okay Priyanka so just check this once ठीक है इसको एक बार आप देखना coming to next question so it is 45 and 46 right कम टू नेक्स्ट क्वेश्चन 35 ये काफी इजी भी क्वेश्चन है और ये हमारा यू नो एक इम्पोर्टेंट मैक्सिम भी है तो आप बताओ टेल मी द आंसर टू 35 क्यू प्रायर एस टेम्पोर पोस्चर एस ज्योर what is the meaning of this anyone who can tell me the meaning it's already written in the question meaning that who is prior in time will be prevailing in law also. Yes, so the correct answer here is good Priyanka, it is B. That is section 48, right? Section 48 of my TP Act is dealing with this thing. And what is section 48 students? Who can tell me? Priyanka, can you tell me what does section 48 say? What does section 48 say? Right. And what is the subtitle of 48? Priority of rights created by transfer है ना priority of rights created by transfer so the correct answer here is 48 very good Priyanka let us move to the next question 36 ये भी easy है आप easily answer कर सकते हो What is the answer to question number 36? Which of the following is an immovable property? So I have got answers D, and the correct answer is D. Tree bearing fruit is an immovable property. Correct. Correct. So all answers given by Durva, Priyanka, Vikas is correct. Okay, come to 37. Right, Priyanka. My voice actually, I went on mute. Now it is audible, Priyanka. Yes, Priyanka. If it is audible, please answer question number 37. Please answer the question number 37. Who among the following is an ostensible owner? A co-sharer, a mortgagee, a hirer of goods, or a guardian of property? Who is a ostensible owner here? For 37. 37D, guardian of property. Okay. Who among the following here is an ostensible owner? Who can tell me? Yes, others also, Durva, Vikas, please attempt it. Even if you like, whatever you feel like, uh, logically you're feeling that this should be the answer, you can mention it. Yes. 37D, Vikas also says guardian of property. Okay. Durva also says, okay, where is ostensible owner mentioned in which section, student? Is ostensible owner defined? First, I want to know in which section is ostensible owner defined. We just did it. Above also we were when we were doing the Binami transaction. We did it right now. Very good. Section 41. Yes, Vikas. Good. Yes, Durva. Right. Section 41 is ostensible owner. And what do you think? गार्डियन ऑफ प्रॉपर्टी चलो मॉडगेजी तो नहीं है हायरर ऑफ गुड्स भी नहीं है राइट बट हु कैन बी एन ऑस्टेंसिबल ओनर guardian of property, right? You are saying guardian of property. And what about co-sharer? What do you think about co-sharer? Don't you think co-sharer can also be, apparently he also looks like an ostensible owner? What do you think about uh, co-sharer? What do you think about co-sharer, students? Yes, it can be co-sharer also, Priyanka says. Okay. Okay, giving you all one more chance. Co-sharer can be the answer because consideration is involved, right? Okay. Fine, fine, fine. So I'll only tell you the correct answer is co-sharer. Okay, the correct answer here will be co-sharer, because when a co-sharer occupies the position of any property, तो क्या होता है, he looks like the ostensible owner to the property fully, right? So co-sharer is the correct answer here. Coming to the next question, ये बताओ आप, ये तो बहुत easy है. 38. If anyone has read section 5 of TP Act, you can easily answer. What will be the answer to question number 38? Answer 5D. Very good. 5D, I mean, for 38, the answer is D, right? All of the above. So, according to section 5, a living person can include this company, association, body of individuals, all three. So, it is D. Also, one thing I would like to say, that people, who cannot be ostensible owner, when we are talking about this question number 37 also, आप याद रखना कि guardians cannot be ostensible owner, trustees cannot be ostensible owner, claimed specialist cannot be ostensible owner, servants cannot be ostensible owner. So the correct answer here is co-sharer. Okay. Now coming to 39, again very easy. सब बता सकते हैं, अगर सेक्शन 3 आपने पढ़ा है तो आप ये बता पाओगे. अटेस्टेशन के लिए कितने विटनेसेस चाहिए होते हैं मिनिमम under TP Act? What do you think? How many witnesses do we require under this section 3 of TP Act? Very good. Yes, all answers are correct. It is B. That is 2 witnesses. Correct. So for attestation in an instrument, it means attested by at least 2 witnesses. Good. Okay. 40. What kind of property here is transferable? Right to re-entry, public office, any kind of property if not prohibited by law, or pension. Which of this property can you transfer? What will be the correct option to this question? 40C. Very good. Yes, very good. Any kind of property if not prohibited by law. तो काफी बार students get confused कि प्रॉपर्टी इज ट्रांसफरेबल या नॉट ट्रांसफरेबल ऐसे लिख दिया, और फिर उनको लगता है कि अरे क्या है. तो ध्यान देना कि यहाँ पे क्या लिखा है, ट्रांसफरेबल प्रॉपर्टी लिखा है या नॉट ट्रांसफरेबल लिखा है. ओके, कमिंग टू द नेक्स्ट क्वेश्चन. ए ट्रांसफर्स ₹500 टू हिज नीस सी इफ शी विल डिजर्ट हर हस्बैंड. राइट. सो अब बताओ, ये जो है ट्रांसफर, ये वैलिड है, वॉइड है, वॉइडेबल है या लॉफुल है? टेल मी. So what kind of transfer is this? Void, valid, voidable? Priyanka says void. Durva also says void. Yes. Under which section? आपको ये illustration किस section में मिलता है? Under which section do you get this illustration, students? Anyone? You can tell me the section also. 25. Again 25. Conditional transfer. If you see, no, section 25. ठीक है, सेक्शन 25 कंडीशनल ट्रांसफर के अंदर आपको ये मिल जाएगा. मैंने अभी अभी एक और section 25 से illustration दिया था about that A letting a farm to be on a condition that he shall walk 100 miles in an hour and the lease is void. Similarly, A transferring 500 rupees to his niece if she will desert her husband. This kind of conditions are void, and the transfer is also void here, right? Okay, next question. A is a Hindu who has separated from his father B, sells to C three fields X, Y, and Z, representing that A is authorized to transfer the same. Of these fields, Z does not belong to A, it having been retained by B on partition, but on B's dying, A as an heir obtains Z. C not having decided in the contract of sale. So, can C require A to deliver Z to him, or may not require A to deliver Z to him, either A or B or none of these? So, X, Y, Z are the properties, okay? So, you tell me what is the correct answer to this. Just see the illustration and tell me. Yes. Same illustration you will find in TP Act also, students. The same illustration. So what will be the answer to this? And under which section, Durva? Durva and Priyanka both are writing A. Under which section? Same illustration. A Hindu, has separated from his father B, sells to C3 field X, Y, and Z, representing that A is authorized to transfer the same of this field Z does not belong to A because it is retained by B on partition. But on B's dying, A as an heir obtains Z. So C not having decided the contract of sale. Can he, you people are saying yes, he may require A to deliver Z to him. But under which section? 43. Very good. Very good. Okay, coming to next question. A lets a farm to B for life of C. C dies, but B continues in possession with A's assent. B's lease is renewed from year to year according to which section? आप बताओ. Can you see my screen? Can you see the question, students? Okay. Okay, now I think you can see the screen. Right now you can see my screen. Question number 43. Okay, okay. Fine. So you all answer this question and tell me under which section and this can be done. So I've got answers, which is 43C. Very good, Durva. Right. It's C, section 116. And what is section 116? It talks about holding over, the effect of holding over, right? So if a lessee or an under lessee of property, like what and what? Yes, yes, Priyanka. Yes, doctrine of holding over. Yes, Priyanka. It's C, because 116 says that if a lessee or an under lessee of property is remaining in possession after the determination of lease granted to the lessee, and the lessor or his legal representative are accepting rent also from the lessee or from the under lessee, or otherwise they are assenting also to his continuing in possession, then the lease is renewed from year to year if there is no such agreement to contrary, or for from month to month also according to the purpose for whichever the property is leased, as whatever is specified also in section 106. So this is the effect of holding over, and if it is assented, then it will get renewed from year to year or from month to month as given under section 116. So correct. So I hope with this I will end the session, but I would want to ask two more questions to you all, right? So I have two more questions to ask, which might not appear on the screen, but I will be telling that and you just need to answer, right? So the first question is, when can gift be suspended or revoked, is given under which section of TP Act? When gift may be suspended or revoked is given under which section of TP Act? And uh, I'm not mentioning the section. This is without option. It's like a fill in the blank. Uh, when gift may be suspended or revoked is given under which section of TP Act? If you all want, I can give you all the give you all the options, but I don't think I need to give because it's an important section. Very good. Yes, Durva and Priyanka, section 126. And my last question for today is on universal doni. Where is universal doni mentioned under TP Act? Where is universal doni mentioned under TP Act? Under which section of TP Act universal doni is mentioned? Yes. So both the answers have start. Yes, they are there on the chat box. Priyanka and Durva says section 128, which is the correct answer. Yes, the correct answer here is section 128. Right. So, with this, I would like to end this session of quiz today. Hope you all enjoyed and hope it will benefit you in your MP judiciary exams also. So, before leaving, I would like to tell you all to go through to always attempt all the mocks which is being especially and exclusively designed for you all. So, don't miss the mock. Try and attempt as many mock tests which is there in your course, also in the bundle also for MPU. I guess you have 10 papers or some papers, many papers which you have, right? I'll tell you how many papers are there for MP judiciary. So for MP mocks, there are 17 papers. Okay, in the judiciary mock and paper analysis course bundle. So go through that. Also go through MP judiciary analysis for preliminary examination. That is also in this bundle of this mock paper analysis, judiciary mocks and paper analysis course. Okay, so don't miss it and study hard, right? Study hard as much as you can. I hope you all come out with shining colors. All those who are present today, hope you all enjoyed the session. Thank you so much and all the best. Thank you, Durva. So I will end the session now. All the best to everyone. Thank you, Priyanka. Thank you, Durva.